Good morning and welcome to the Appellate Division First Department. I will now call the calendar. People versus El Amin. Appellant has 6 and 2 granted for argument. Respondents 8. Counsel present?
Yes, Your Honor. Counsel for Appellate present.
Yes, Your Honor. Counsel for Respondent present. Good morning.
Thank you. Good morning. Capstone Business versus Sanita Partners. Are counsel present? We will call that at the end of the calendar. Administration for Children's Services is submitted. U.S. Bank versus Cordero is submitted. Williamson versus 3940 Carpenter Avenue. Appellant has been granted 5 and 1. Are you present?
Yes, Your Honor.
Thank you. We need your volume to come up when we go live. Respondent, you have been granted 6 minutes.
Sorry, good morning, Your Honor. I'm present. Thank you.
Wonderful. Next case, People v. McCray. Appellant, you've been granted 5 and 2. Present?
Good morning, Your Honor. Julia Burke for the Office of the Appellate Defender.
Good morning. And respondents, you've been granted 4. Are you present?
Yes, good morning, Your Honor. Lori Farrington for the respondent.
Good morning. Phipps versus SASBS Myrtle Beach is submitted. 2 of those cases. King Penguin versus Spectrum Group. Counsel for respondent, are you present?
Yes, Andrew Van Houter for respondent.
You've been granted 4 minutes. Appellant did not request time. People v. Alberghetti. Counsel?
Good morning, David Clem for appellant.
And my apologies if I mangled the name. Counsel for respondent?
Yes, Morgan Damian for respondent, and I'm appearing under the supervision of ADA Lori Farrington, who announced her appearance in People v. McCray.
And I will remain on to supervise ADA Damian.
Thank you both and welcome. Board of Managers versus 90 William Street. I understand there is one counsel arguing for both parties as appellants. Counsel?
Yes, good morning, Your Honor. I'm sorry. Good morning, Your Honor. Lawrence Lebowitz arguing on behalf of all appellants this morning.
You've been granted 5 and 10. Would you like to reserve any of those 15 minutes for rebuttal?
I would, Your Honor. I'd like 12 and 3 if that is okay with the court.
That is fine. And respondent, you likewise have been granted 15 minutes.
Yes, good morning, Stephen Orrell for respondent.
Welcome. People v. Sean Bowser is submitted. Madison Avenue 1 versus Maruch is submitted. Hidalgo versus Vasquez is submitted. Tate versus O'Neill is submitted. People v. Giorgio White is submitted. Zemsky versus Prokofiev. Again, apologies if I've mangled the name. Counsel for appellant, you've been granted 7 minutes.
Good morning, Your Honor. Sarah Mahoney for appellants.
Good morning. And respondent, you've been granted 7 minutes.
Good morning, Your Honor. Leilani Rodriguez for the respondents.
Good morning. Lewis versus NYCHA. Appellants, you've been granted 5 and 2.
Good morning, Your Honor. Judith Whiting for appellant.
Good morning. And respondents, you have been granted 7.
Good morning, Seth Kramer for respondent.
Good morning. Amar versus New York City is submitted, and Jenkins versus River Bay Corporation is submitted. First case on the calendar, People v. El Amin. Ms. Everett, you have 6 minutes.
Good morning, Your Honor. Abigail Everett for Appellant. I addressed the adjournment issue in the reply. I'd like to begin, please, with the argument that the court below improperly limited the defense from cross-examining the detective about allegations in a lawsuit. Now, the court held there was no good faith basis. If in the Court of Appeals in Smith dealt extensively with the rights of defendants to cross-examine police officers, not about the existence of the lawsuit, but by the underlying facts.
Counsel,
Now,
this is Justice Moulton. You're talking about Officer Schneider. What do we know, and what was the proffer concerning where Officer Schneider was concerning the alleged warrantless intrusion into the home? I mean, what do we know about his whereabouts? Could he have been in front of the building, for example, and they're not been present, and therefore not been complicit in the alleged illegal action?
We know that he was alleged to be a participant in the illegal arrest. We don't know his specific role, but I would point out, Your Honor, I know that people rely on Cepeda, a case where Your Honor and Justice Mansonet Daniels held that there was insufficient connection to the particular officer involved to warrant a good faith. But that was a very different case. In Cepeda, the only allegation was that the officer who was being cross-examined only signed the accusatory instrument. This is a case where it was alleged that Detective Snyder participated in the actual illegal arrest at the house. It was an allegation that the warrant team...
Aren't there a plethora of cases in this department that say there has to be more specific detail about the actions of the officer who you wish to cross-examine with respect to the prior incident? There has to be more of a factual basis in order to allow that kind of cross-examination into what might otherwise be considered collateral.
Well, Your Honor, this court held in McGee, that was later reversed by the Court of Appeals, that there was an insufficient connection. And I think if you look at McGee, you'll see that the Court of Appeals does not require the specificity of the allegations that Your Honor is suggesting in that question, that it's sufficient for the defense to have pointed out and good faith. The allegation was that this detective participated in misrepresenting, the 4 detectives that misrepresented that they had an arrest warrant when they did not have an arrest warrant, and we don't know which officer put his foot in the door. Can you hear me? I'm getting a notice.
If I may,
Yes,
excuse me for interrupting you. It's difficult with all of the virtual things, but even if we were to agree with you, I kind of want to say, so what? Detective Schneider in this case, I think, really only testified about the victim's injuries. And the physical element, we have a lot of other testimony and evidence in the record with regard to the physical evidence, the physical injuries. So even if we concluded it was wrong to exclude that cross-examination, I don't see the value to you of it. And we could always, if that was the case, it could reduce itself to a harmless error analysis. So what is so important about what Detective Schneider has to offer in this case in any event?
Well, Your Honor, there was a disputed trial about the injuries. The complainants testified about allegations, but the hard evidence was in the hospital records was very limited. And in fact, this detective, one thing was he purported to have taken photographs of the injuries, but he lost the photographs and there was an adverse inference charge given to the jury. So this would be another instance of an attack on his credibility regarding the injuries. And the defense argued in summation.
Are you suggesting, counsel, are you suggesting that having a wooden chair crashed over your head would not cause any injury? The man was not unconscious for at least a few minutes, right?
He was knocked unconscious, But a number of the injuries in this case, and we have to keep in mind that there was no serious physical injury for the whole event, but a number of the injuries that were stated occurred during the fight in which the complainants were participants. We want to remember that the defendant wasn't charged by the grand jury with any assault in the fight that preceded that, and the jury acquitted him of assault on the allegation that he had kicked the person with his shoe. So when you look at the injuries in this case, and again, they were not serious injuries in any event, a number of them have to be attributed to the fight that preceded. Now, I'd like to turn to the excessive sentence argument, if your honors permit. This is a person who's doing 9 years.
Make it quick. You've already run out of time, so I will
Well,
give
then
you
why don't I
additional-
wait to the reply and I'll deal with it then, your honor.
Very good. Okay. Mr. Wolkowitz, you
Yes.
have 8 minutes.
Good morning.
Good morning.
If I could just, I don't know what they're going to say about the sentence, so if I could just mention from our standpoint that just as coming, I'll get to the portion about the civil suit in 1 second. I just wanted, so I get a chance to say something about the sentence, just say that as you were talking about earlier, this is somebody who smashed a wooden chair over the head of 2 smaller people, and the court found, I just want to say this, the court found that it was nothing but luck that separated them from not getting serious physical injury. So if I can, now, if you have no other questions about the sentence for me, I would then ask if I could.
The sentence is a subject of some discussion, and I believe that we even have some amicus briefs on that point in behalf of the defendant and his community leadership and community work. Does he have any prior, I know he has an extensive criminal history, is that correct?
That is correct, Your Honor.
But they were not violent crimes, is that correct?
That is also correct. They were not violent crimes, Your Honor.
So what were they?
I believe they were more of, there's a forgery. I believe we listed them in our brief. They're from out of state. He was not a predicate felon. All those were true. I think what the court focused in on here was the actual crime that the court saw with its own eyes and saw how violent and how it could have, but for luck, caused much more, injury to the victim. I mean, the tape, which I believe counsel submitted to the court, is there for the viewing, and it's cringeworthy. I mean, you could hear, like, you could see everyone in the place murmur because it's so, it's such a violent blow. I think that was what was the focus of the court sentence.
Should we not consider the fact that, as you say, the complainants here were quite fortunate in that they did not sustain greater injury? And in light of that, is not 9 years excessive?
No, 9 years is not excessive, Your Honor, because while the complainants were lucky, we are also punishing the conduct, not only the result. I mean, he was convicted of attempted assault 1. If they had caused a serious physical injury, then he would have been subject to a much greater sentence.
I understand, but I have had, in the last 11 years on this court, had cases with murder with less sentences than 9 years. So explain to this court why 9 years in the scheme of our system, in the criminal justice system, why that is appropriate in light of the lack of serious injury, arguably.
As I said before, Your Honor, and I will not repeat just about the violence of it. There was also no contrition. He left as soon as he smashed him. He left the restaurant. He never even, stayed to see if the victim was okay. There was some talk about sentencing. I mentioned this in our brief about the fact that the defendant gave an interview, and even to this day, in his own brief, the defendant does not take responsibility. He sits there and completely calls, and it's true to the extent that the victim did throw the first punch, or it was the first attacker, I would say, but it was such a soft blow, and he still doesn't realize the gravity of what he has done, which I think also was off-putting for the court and shows that, the defendant is not repentant or, seeking acceptance of responsibility for what he particularly did here. So for those factors, that is why I would ask the court to sustain the 9-year sentence, and that is not excessive. That was fair and reasonable under the circumstances of this particular case.
Okay. Anything else?
Should I go on to the?
Yes, you may. You still have 4 minutes.
Yeah, just as to the point regarding the civil lawsuit, as your honors were discussing, is the people's position. There was no specific allegations. What the lawsuit did was it said defendant officers, and then each time would list the 4 officers on the team. As Justice Moulton was asked counsel, was one of the things that we're arguing is, look, there was nothing in that that showed where this officer was. How could he have heard it? How could he have, we don't know if he heard it. We don't know where he was when the foot was in the door. We don't know anything about this officer. And the whole purpose of Smith is to put specific allegations in front of the jury. There was no specific allegations in this particular case. Just want to make sure. And if the court has no further questions for me, I would give back the rest of my time. And
thank you.
Oh.
Ms. Everett?
Your Honor, on the
2 minutes.
sentence issue, I would stress that this is a man who does not have a history of violence. He did not initiate this fight. The act with the chair
Counsel,
appears
impulsive. If I recall the fact pattern correctly, this fight was stopped twice, and this last hit was unprovoked.
Your Honor, when you look at the video, you have to remember that this
We did look at the video, and it's horrifying, counsel. It's horrifying.
Well, he's on his way towards the door. The chair is right there. The complainants are right there. It appears to be an impulsive act that really doesn't warrant 9 years in prison, considering the other positive things about the defendant that we haven't addressed yet. This is a man who had a horrific...
Sorry to interrupt. This is Justice Moulton. The people mentioned the fact that he doesn't show much remorse in his pro se brief. Can you address that?
Well, although he continues to maintain his innocence, Your Honor, he did... I would say that remorse is, while relevant, not enough in this case to warrant the 9-year sentence. He is a person who was victimized by his father as a child. He had suicide attempts. He has a mental health history. He's HIV positive. And yet, despite that, he documented that he has a history of charitable work in the gay community. He's done a lot of volunteer work. Many people who did know him submitted support letters on his behalf. 9 years for a fight that took less than 2 minutes, even though it did end in the act of violence with the chair. This is not something that really characterizes Mr. El-Amin's personality as a whole. It's viewed as an impulsive, perhaps serious overreaction in the context of a fight he did not initiate.
Okay.
Both of the complainants. So for that reason, I would ask the court.
This is Justice Kennedy, and I like to go back when you talk about impulsive, because there were 2 altercations that ended, and the 2 complainants went to another area, and the defendant approached both complainants from behind and smashed the chair over their heads. And then when we talk about remorse at the sentencing, he indicated that one of the complainants approached him with a weapon. That was a tote bag. That was the first incident, which had already ended. So can you address that? So I'm not clear about why is it impulsive when it was over. He approached them from behind.
I think that the incident can't be divided up so clearly into beginning and ending parts. The whole thing is very fast because in each of the 2 times that it was separated, the complainant himself reinitiated. He admits that he's It's 10 seconds elapsed between when they were pulled apart and when the defendant hit him with a chair. It's not a situation where there was a real pause and then he reinitiates it. Thank you, Your Honors.
Thank you so much. Okay. I'm going to skip over Capstone as I have not heard whether they have arrived. Williamson versus 3940 Carpenter Avenue.
Yes, Your Honor.
Ms. Finocchio?
Yes.
Am I pronouncing your name correctly?
Tokyo.
Okay. You have 5 minutes, ma'am.
Thank you, Your Honor. May it please the court, I am Carol Finocchio. I am here for the defendants appellants 3940, Lemley, and SG2 Management. At the outset, the party that employed the superintendent who committed the horrible sexual assault was Lemley. So I'm going to focus on the negligence hiring claims against Lemley. Here, this is a lack of duty case. There was no duty to investigate the superintendent's background or prior criminal conviction because he was inherited with the building. Both SG2, which was the prior managing agent, and Lemley, they inherited him. He was hired in 2006 by a company called Rental Masters. He worked at the building without incident. The infant plaintiff's mother testified that there were never any complaints about him. She knows of no complaints about prior, misconduct on his part, and therefore there was no duty to perform a background check and no duty to investigate or to try to find a criminal record. So the plaintiff's position is,
Ms. Finocchio, if they had been hired directly by your client, would there be such a duty?
Well, actually, there would not be a duty in that instance either, Your Honor. What happens is you look at the person's policies, but as a matter of law under this court's case law, I'll give you an example. This court's decision in Newell versus 345 Wadsworth, which is in our main and reply briefs. In that case, the building hired a registered sex offender as a porter because they didn't do a background check. And what the court held was the court dismissed the negligent hiring claims, this court did, saying there's no duty to do a background check. And I think that's because of public policy, obviously. If someone
Is it public policy or the lack of legislative action? Because we have laws on the books that requires schools, daycare centers, all kinds of businesses and industries have to do checks if the person they're hiring is interacting with children. And yet this industry has been freed from that obligation that almost every other industry must abide by if they are at all exposed to children. Isn't that the real problem?
Your Honor, I don't know how to address what the legislation says because it's not discussed in the parties' briefs. But I would say that under the current state of the law, including from this court and the cases in our brief, there was no duty since he was already part of this building. It wasn't.
I understand. I guess I am just reacting to your statement that this court's public policy. And I kind of take issue with that because I don't know of any court that thinks it's okay to allow sex offenders to work in a place where they are around children. So I suppose that's what I'm taking issue with. I don't think it's a public policy issue. I think it's a lack of legislative action on the issue.
Well, Your Honor, I wouldn't, I put it this way, I would not find fault with what you're saying, but I would simply say that based upon the case law, there's no obligation in an instance such as this, having no knowledge of any prior problems with this individual. And therefore, there was no background check. The plaintiff relies on the forms that are in the employment record. There's a W-4 form and an I-9 form, but they're payroll processing records. So they wouldn't give.
You know, the whole point of sex offender registration is that the public, when you have a level 2 or level 3 offender, and I don't know what this particular individual, how he was graded because it's not in the briefs, but if I had to suspect, I would say he was up there in one of those 2 levels because of his convictions. But the whole point of these statutes is to give the public the opportunity to find out if there's a sex offender living near them, that they have to exercise greater diligence and greater protection of their children because of the presence of these people. They're not allowed to live within a certain number of feet of a school even. That's the whole point of these sex offender registration acts, so that the public has the ability to be on notice, to know about it.
Yes, Your Honor, I'm aware of that, but the problem that we have here is that he used an alias. And based upon the employment application, we would have no reason to know that. And in fact, when he pleaded guilty as a sex offender, in this instance, after this horrible event, the district attorney noted on the record that they had trouble finding his prior sex offender registration because of the use of an alias. So we submit that based on the documentation that we had and the lack of complaints about him, and the fact that he had worked at the building for many years at the time of this incident without any incident, that there was no reason for us to come forward and conduct an investigation. And unless there are further questions, Your Honor, I will rest on my briefs.
Thank you. Okay, Ms. Rosen.
Good morning, Your Honors. Jillian Rosen for the respondent plaintiff. In this case, it's not just about the sex offender. It's the failure to undertake an investigation of the application that would have led to that knowledge. There is,
but as counsel pointed out, there is no duty to do so. So you have to. How do you get past that hurdle here?
Because for example, in your decision, TW against the city, there is a duty to investigate prospective employees' backgrounds. It's not a matter of whether you're investigating if they're ever a criminal history. It's to investigate their background when an employer knows of facts that would lead to a reasonably prudent person to investigate the background.
But there the employer was the city of New York, correct?
It was.
Okay, but I think we have a completely different scenario here. And you need to address how, again, under our case law, a landlord doesn't have an obligation to do a background check. So how do we address that? I mean, I turn the public policy issue that we discussed earlier on you. So I understand, I think it's clear that we want to protect children, but there is nothing in the books that would require a background check in this instance.
Your Honor, my position is that even though against TW against the city, the duty was because there are facts that would reasonably lead a prudent person to investigate. And there are other cases in my brief, before I get to the facts of this case.
Counsel, if I may, I want to go back to TW, because in TW, the janitor admitted a criminal conviction, which is much different than what we have here. The bottom line is, because of the various aliases and the social security numbers and the lack of any complaints regarding any prior conduct, this is not at all like TW, where the janitor admitted a criminal conviction, which is not what we have here.
Yes, Your Honor, but this is what we have here. Let's look at what Lemley's procedures were, okay? So Lemley's procedures were, at the time of this incident, they did background checks on new hires. That Mr. Caguano testified that they did background checks on new hires, and the purpose was to ascertain the integrity of the person. He did not explain why they didn't do background checks on inherited employees. And our position is that an inherited employee and a new hire is one of the same thing, because each time a new managing agent inherits, quote unquote, an employee, it is new to that company. So Lemley had a procedure in place to do background checks on new hires. And they admitted that they did not do any background check because he was an inherited employee. They also admitted that they never reviewed his employment file. This is not a case where they didn't know it's not a case where this employment application was artfully done and you couldn't tell. For example, what my adversary brought up, if you look at the employment file and you look at, for example, 487 of the record, so you have a W-4 with the social security number of a woman in Florida. Then at 491, you have a W-4 with a different social security number of a woman in Florida. You have two I-9 forms, which is at 489 and 495 of the record, that are different social security numbers with these women in Florida. Then you have a date of birth on a resident alien card that is a different date of birth. Then you have it in the employment file that was created by SG2. And what's really interesting about the verification form, if you look at 495 of the record, that resident alien card allegedly expired in November of 09. This was all in front of these managing agents' nose. So
okay, counsel,
yeah.
You're right. That was all available. How does that put the landlord on notice that he is potentially a sexual predator?
Because they see this application that's riddled with fraud, that's riddled with inconsistencies, and that said, well, wait a minute, this may not even be a real person. This person can just be an amorphous creature that doesn't exist. That would have led to an investigation of this application would have led to the sexual deviancy that this man.
So you're saying that when a new person acquires a property, they have the obligation to review the employment files and applications of all the current employees that they, as you said, inherit, to evaluate those and to conduct a new investigation. That's their duty.
I do see that. I want to point out while I'm saying that is that we don't have a deponent from the building, right? So we have a deponent from SG2, which was the managing agent that existed before the incident. And then we have Lemley. The owner, this is a building superintendent. It's not clear whether he was an employee of the building or he was an employee of Lemley. What we know is that he was a superintendent of the building, a resident superintendent that, ironically, was in charge of security of the building. He's in charge of safety. He enters tenants' apartments. And Lemley testified, first of all, Lemley testified, he's not my employee, but Lemley fires them. And what's really telling to me about this case is the letter, the termination by Lemley at 475 of the record, supports our position that an inquiry was necessary based on what they knew, because in the termination letter at 475 of the record, Lemley doesn't just fire this super because of the sexual assault on this 5-year-old girl. They fire him because he falsified records and he provided false information in his application. The very reason which was in front of them, the very reason which they should have undertaken an investigation of the application. Now, okay. One other thing.
Counsel, your time is up. Thank you. I think we've got your argument.
All right. Thank you.
Right.
Okay.
All right. Counsel, you have 2 minutes.
Your Honor, unless there are questions, I will rest on my reply brief, which I think rebuts the arguments that counsel has made.
Okay. My colleagues, any questions? Thank you so much.
Thank you, Your Honor.
Thank you.
Thank you.
People v. McCray, Ms. Burke, you have 5 minutes.
Good morning. Julia Burke for the Office of the Appellate Defender for Lonnie McCray. Mr. McCray's trial counsel committed a cascading series of egregious errors which deprived Mr. McCray effective assistance of counsel at every stage of the proceedings in this case, and his conviction must be reversed, or in the alternative, this court should remand for a 440 hearing. Counsel's errors alone turn this case from a shaky single eyewitness identification case into a joint trial with an antagonistic co-defendant and 3 in-court identifications. Counsel's admitted mistakes affirmatively helped the prosecution's case and did not constitute meaningful assistance. Counsel first erred when he declined the trial court's offer of severance from the co-defendant, a move that Judge Fabrizio described as
the record. Excuse me, but doesn't the record indicate that that was the desire of your client, a very forceful desire of your client?
Yes, Your Honor, it does indicate that. However, it is a decision for counsel to make at the end of the day.
Yes,
And
but counsel has to be guided and greatly influenced by his client's position in matters such as this. He has an obligation to abide by those decisions in many instances.
he does, but this is not one of the critical decisions that rests with the client, unlike a decision to testify or to waive a jury. This is ultimately a decision that rests with a seasoned trial attorney. And in fact, in this case, counsel admitted later on that when making this severance decision, he did not consider the full impact that the co-defendant's Molyneux motive evidence would have against his client when he proceeded to a joint trial. He admitted that to appellate counsel when the 440 proceeding was filed. And these were antagonistic defenses under the facts of this case. So that was an error to proceed. And again, Judge Fabrizio stated that it was mind-boggling, and he offered severance and said it was if he wanted it, he could have it. Secondly, trial counsel erred by waiving preclusion of the untimely notice identification testimony.
You know, this was the, I happen to have been on the panel that considered the co-defendant's appeal, and that was the main issue, the severance issue. And we held that counsel did not improperly delegate the decision to her client. So I don't see how that decision is different here with regard to severance.
Your Honor, respectfully, the decision is different between Mr. Butler's case and Mr. McCrae's case for a couple of reasons, namely that Mr. Butler's statement would not have come in at a separate trial for Mr. McCrae. Mr. Butler made a statement that said that he was at the scene and admitted his defense was a defense of motive, whereas Mr. McCrae's defense was a defense of misidentification. And that statement would not have been relevant to Mr. McCrae's trial if it had been severed, and it would not have come in. So it is a separate distinction in terms of the severance on that. And so if I may move on to the preclusion, trial counsel admitted that he was not aware that by litigating suppression, he was waiving preclusion. And there's no ambiguity in the law here, Your Honors. This identification should absolutely have been precluded. Judge Fabrizio said unequivocally that it should have been precluded. And the prosecution even conceded in their 440 motion response that this was an error on counsel's part. And this error helped prove the prosecution's case by allowing in the devastating testimony of this key eyewitness. And it further allowed for further errors on counsel's part down the line in the trial. And again, counsel admitted he didn't know. So any decisions he made down the line could not have been strategic when he waived this crucial preclusion of the only eyewitness who claimed to have seen Mr. McCrae actually shoot the victim in this case. And,
thank you. You have 2 minutes on rebuttal. Okay.
On rebuttal, I would just like to address the trial errors. Thank you.
Very good. Ms. Farrington?
Good morning. May it please the court. Your Honor, the record clearly reveals here that at every stage of the trial, the defendant received meaningful representation as well as effective assistance of counsel. There is a very lengthy contemporaneous record in which counsel reveals...
Okay, this is Justice Moulton. Can you pick up the thread of Rochester Sumter's testimony and why it shouldn't have been precluded? First of all, he was the only eyewitness to the shooting, correct? Mr. Diaz did not see the shooting, correct?
No, Mr. Diaz's testimony picks up exactly where Mr. Sumter's testimony leaves off.
So then
Mr. Sumter sees the shooting.
Counsel, please listen to the questions.
I'm just talking about the centrality of Mr. Sumter's testimony. And it was so important. If it had been precluded, don't you agree that that might have led to acquittal?
Absolutely not. What I was trying to explain is that Sumter's testimony, coupled with Diaz's testimony, implicitly identifies the defendant.
That is the point. That
And
if Diaz's
So you
testimony
lose that link
were
in the
not
chain.
allowed. Go ahead, Judge
You
Moore.
lose that link in the chain. Go ahead,
May I respond?
please.
Yes. Along with Diaz's testimony that he sees the defendant standing over the body with a gun pointing at him, counsel would have been quite hamstrung to present the arguments that he did, arguments which have proven to be very successful in front of Bronx juries, that being that Sumter used the misidentification of defendant in order to get a, quote, get out of jail free card, and also that the police single-mindedly pursued defendant, and that there was that the police investigation was severely lacking. Counsel would not have had those arguments had Sumter not been able to make an in-court ID, because he would have been severely hamstrung to question Sumter's ability to ID without opening the door.
You know,
so the arguments he presented.
We have to also consider here, well, first of all, I think Bronx juries are probably as wise and fair as any other jury that we
absolutely
have to look at. But we also have to consider how the trial court handled the 440 decision application. And we have to consider the fact that counsel on the 440 refused to submit an affirmation describing what the reasons were for the decisions that they made. And one of the fundamental questions here is, should we have a better record? Should we have a fuller record? Should there have been a hearing at which the counsel was compelled to testify and put their reasoning on the record? You know, so that we can make an informed decision. Thank you.
Thank you. The reason that the court's decision to summarily deny in this case was proper was because, as your honors are aware, pursuant to Satterfield, to be entitled to a hearing, you not only have to show the dispute of a material fact, but that you would be entitled to relief. Even if we assume that counsel's waiver of preclusion was an error because he didn't realize that he was waiving it when he cross-examined Sumter, defendant is still not entitled to relief because A, counsel's decision was objectively reasonable, and B, there was no prejudice given the vast amount of overwhelming evidence.
Be objectively reasonable when the 7/10/30 notice was not provided at arraignment, and under the case law, you're entitled to suppress that statement on that basis or that ID.
Well, in fact, appellate courts have found that this is a reasonable strategy because it grants counsel, A, an opportunity to question an eyewitness and prepare impeachment material for trial.
Not if that eyewitness could be precluded, counsel.
His testimony wouldn't be precluded, Your Honor, only the in-court identification. His testimony would stand.
That's what needed to be precluded. That was the damning evidence.
Except that it would have hamstrung counsel severely on his argument.
That's
to
his problem.
Discredit Sumter.
That is defense counsel's problem.
Yes, but that's where the strategy comes in, and that's where counsel has to make a decision. Do I have a stronger argument?
So then going back to Judge Mazzarelli's point, how can, in light of there being a valid argument that that strategy was ineffective as a matter of law, would we not be required to hear the reasons in order to fully evaluate a 440 application?
Not if there was meaningful representation and no prejudice, no. And here, the overwhelming evidence shows that even without the explicit identification, there was overwhelming evidence of defendant's guilt and meaningful representation throughout the trial. So no, not on this record, no.
Thank you. Ms. Burke, you have 2 minutes.
Thank you, Your Honor. So just to respond briefly to that, I would just note for the court that but for counsel's mistakes in this case, there would not have been what the people characterize as overwhelming evidence. This counsel's decisions let in a great deal of evidence that would otherwise have either been precluded or would not have come in before the jury. And I do want to turn briefly to the jury note issue in this case. The record is clear that the jury sent an additional note to the court, which was never addressed. Judge Fabrizio says clearly on the record, quote, "You have another note, there's another note," but fails to follow the proper procedures following up on that afterwards. And this failure requires reversal. And secondly, I do want to touch on the independent source issue. Mr. Diaz's identification was based on a photo array, which was very suggestive. Mr. McCrae was both the darkest skinned individual in the photo array, and his photograph was the darkest photograph. Counsel rightly said that Mr. McCrae stood out like an eyesore in that photograph, and an independent source hearing should have been granted on that basis. And additionally,
Thank you so much.
Thank you.
Thank you. Have a good day. Okay, King Penguin versus Spectrum Group.
Good morning, Your Honor.
Good morning.
Good morning, and may it please the court. My name is Andrew Van Houter from Faegre Drinker, Biddle and Reef. I'm here on behalf of Respondent Spectrum Origination LLC. Appellant King Penguin attempted to bring claims here for promissory estoppel, negligent misrepresentation, and fraudulent inducement, and breach of the covenant of good faith, all based on proposed loan terms set forth in an explicitly non-binding term sheet. In decisions from this court that King Penguin either failed to cite or misrepresents, this court has repeatedly held that such claims cannot stand as a matter of law. So for promissory estoppel, negligent misrepresentation, and fraudulent inducement, the appellant would have to show justifiable reliance. This court in Starvest Partners, a decision which Justice Mazinette Daniels was on the panel, held that there can be no justifiable reliance as a matter of law, quote, where a term sheet explicitly requires the execution of a further written agreement.
So what you're asking us to do, I think, is to affirm the trial court. Is that correct?
Absolutely, Your Honor. It should be affirmed in all respects. So they don't make any real arguments. They don't contend with the precedents from this court, let alone try to distinguish them. They don't cite Starvest Partners, even though it was a point of the basis for the trial court's decision below. But they do cite GE Oil and Gas in supposed support of their argument. But GE Oil and Gas was a decision from this court from last year, which affirmed Starvest Partners and held that a fraud claim would fail for, quote, lack of justifiable or reasonable reliance because the term sheet explicitly required definitive documentation before it could constitute a contractual commitment. And here our term sheet stated in boldface and italics that the term sheet is for discussion purposes only and does not constitute a binding commitment to provide credit. Any such commitment is contingent upon satisfactory completion of due diligence and execution of written loan documents. Under this court's precedents that King Penguin just ignores, their claims fail as a matter of law. So does their claim for breach of covenant of good faith and fair dealing. First and foremost, the term sheet's not a contract. There can be no covenant of good faith and fair dealing. That was this court's decision in Starvest Partners and Jordan Panel. And while we use due diligence expenses, the term sheet actually said you can use up to $100,000 as initial expenses, and if you need more, you can come back for more. We used $80,000 for due diligence expenses, and all for the $20,000 that we didn't use back, even though we had no requirements to do so. That cannot be a breach of the covenant of good faith and fair dealing. I think our arguments are set forth in the papers, and the appellants making numerous other arguments that have no basis in law. I think it's telling that they didn't even bother to request oral argument to defend those positions. Unless the court has any questions, I'm happy to rest on our papers.
Thank you.
Thank you, Your Honors.
People v. Albergati. Mr. Clem.
Good morning, Your Honors. David Clem for Ramel Albergati. A 22-year sentence for a 22-year-old first felony offender is excessive to be sure this
Well,
was a
let's
homicide.
be clear, this wasn't like a first offense of a shoplift. This was the most serious thing that anyone could do.
Absolutely. It was a homicide offense. It is worth keeping in mind that the decedent also had a gun. This stemmed out of an argument, and that's not a defense to any of it.
There's no allegation that the decedent attempted to shoot at the defendant. No.
No, it wasn't. I mean, it's not a justification defense.
So what does that mean? Why is that relevant?
Well, I mean, it's not. We see a lot of different types of homicides, as this court is well aware. A 22-year sentence is quite high for that, as Justice Manzanet pointed out in the first argument today. This court sees sentences of less than 9 years in homicide cases. So, there needs to be a reason why a 22-year sentence can be justified. And there was nothing about the facts of this particular homicide that would warrant such a lengthy sentence, and certainly nothing about the background of this young man with no criminal record whatsoever, who was acting under the influence of alcohol. And again, I'm not saying that as a defense in this case, but in terms of mitigation of the argument, the fact that he was impaired by alcohol.
Counsel, if I may, Justice Kennedy, because we just have the defendant's word that he had alcohol prior to the shooting, but I want to go back. How is this sentence unfair when he received the sentence that he bargained for? He bargained for this sentence. He received the sentence that he bargained for.
Sure, and that, of course, doesn't limit this court's ability to modify sentences, as Your Honor is well aware, in the interest of justice, merely because it was bargained for. In this case, as Your Honors are undoubtedly aware, Justice Fabrizio is a very harsh sentencer, and the choice before our client, the evidence was, of course, overwhelming, so the choice was to go to trial, and he would be convicted undoubtedly of murder and face life at the back end, or take whatever deal the people were offering, and this is the deal that he took.
Well, I want to go back because obviously the attorney who represented him for I believe it was 2.5 years while this case was going on. It's clear that counsel continued to discuss the options with the defendant, indicated on the record that he discussed over time the bargain plea. He was satisfied with counsel's representation, and the case law is clear. When you have the colloquy along with a detailed written waiver of appeal, that is what we have here. So why is that not knowingly, intelligently, and voluntarily made?
I mean, there's two aspects there. Let me discuss the waiver first. The people here don't even defend the waiver, and there's a good reason for that. This waiver is completely flawed. The court never indicated in any way that someone pleading guilty would not necessarily have to waive their right to appeal. Instead, the court indicated exactly the opposite when it was discussing the written waiver, telling Mr. Albergati that the written waiver was required for every defendant who pleads guilty. That language is utterly damning to the appeal waiver here, and the people are absolutely correct in not even defending that appeal waiver. It can't possibly be defended. I'd also note that the court went on and was completely incorrect in its legal advisements as to what issues would be waived. There's nothing good about the waiver of the right to appeal, so there's no impediment to this court reviewing the excessiveness of the sentence here.
Okay, you'll have a minute on rebuttal, okay?
Thank you, Your Honor.
Ms. Morgan Namian?
Morgan Namian. May it please the court.
I'm so sorry.
No problem. Well, it happens all the time. I'm here on behalf of the Bronx District Attorney, and I'm arguing under the supervision of ADA Lorianne Farrington, who is also on the call. Defendant here validly.
Yeah, counsel, I was just going to say, the waiver is point one in your brief, the defense of the waiver.
That's correct.
Yeah.
And our position is that defendant validly waived his right to appeal, meaning that his excessive sentence argument is unreviewable in this case.
Okay, but can you address counsel's arguments with regard to the inadequacy of the oral waiver, which I must concur left something to be desired?
Well, to the extent that there is any ambiguity in the oral advice that the court gave at the time of the plea and later at the sentence, there was, as was noted earlier, a detailed written waiver that defendant not only signed, but that his counsel in the beginning of the plea, confirmed that they had discussed the appeal waiver. Furthermore, the people can require an appeal waiver in these circumstances, and the court was very specific when it said that the people, and not the court, it didn't say not the court, but the people require that in order to, in consideration of this plea of guilt, that defendant waive his right to appeal.
In any event, we can still consider the arguments that Mr. Clem's making in the interest of justice. Isn't that correct?
Not where the defendant did validly waive his right to appeal. Specifically, the written waiver did note that by waiving his right to appeal, he was foreclosing his ability to raise claims about the length of his sentence on appeal. So I think that was specifically noted in the appeal waiver. And insofar as defendant.
Well, I'm speaking only for myself. I don't think that the district attorney's office can divest this court of interest of justice jurisdiction in any case, but that's just my opinion.
And I understand. I think it's also worth noting here, though, that the court did twice note that the appeal waiver was a separate condition of the plea, emphasize the fact that the people were requiring that condition. And in any event, the plea court was there, observed the defendant's behavior and his demeanor, and accepted the waiver in the end as presumably voluntary, intelligent, and knowing.
Why don't you address the issue of the excessive sentence, the 22-year sentence?
Sure. So as you know, the defendant in this case is initially charged with second-degree murder, so he was facing life in prison. As compared to that, being able to come down to the first-degree manslaughter count, not only was he facing a much lighter sentence of a maximum of 25 years, but at the same time, this crime was heinous. He shot and killed someone on New Year's Eve. He laughed at the victim's mother during sentencing as the mother was giving her victim impact statement. Insofar as
counsel explained that was defendant's nervous reaction. Some people laugh under great stress. Is that something that was observed over the long period of time that this case was pending?
So defense counsel did notice or note that he had explained this fact at previous proceedings. I'm not aware, or I didn't read the minutes from those previous proceedings to know whether or not this was, an issue that was
ongoing.
Sure, yes. But at the same time, I think it is pretty important that the court was, the plea court was there and was able to observe the defendant on multiple occasions, specifically noted and made a record of the laughing at sentencing at plea, and then also made note of the fact that, the defendant had to be extracted from his cell 2 different times in order to show up for sentencing. It had been on for sentencing 4 different times. And I think, if I'm not mistaken, the court also noted that in the past or at past sentencing, the victim's family, that the defendant's own family had shown up, but defendant himself had not shown up. And so I think those factors also weigh heavily in favor of finding that the sentence was imposed properly, that it was imposed after, it was negotiated ahead of time. It's a significantly more lenient than the sentence that he could have received for, had he gone to trial on the second degree murder count.
It's only three. It's only 3 years shy of the of what he would have gotten after trial. It would be 25 to life. So he shaved 3 years off the top and saved himself a lifetime of parole. That was the benefit.
And he also avoided, facing an indeterminate sentence. He had in receiving 22 years determinate, that lends some predictability to the sentencing. Whereas had he been facing an indeterminate sentence from 15 to life to 25 to life under the murder 2 count, that could have changed a lot for him in terms of sentencing. In any case, I think it's important to note that the court specifically stated to defendant, you got away with murder by pleading guilty to manslaughter. And I think it's important to note that. Also, to the extent that
Counsel. You're out of time, but thank you so much. And Mr. Clem, I believe you have 1 minute.
I just want to use my time to apologize. I completely misstated the people's position and accidentally misled the court. I had a brain freeze. Of course, the people are arguing that the appeal waiver is bad here. We dispute that vociferously, but that was entirely my mistake. I'm sorry about that. And my adversary did properly point out that had he been convicted of murder, the sentencing range, it would be an indeterminate sentence, but the minimum there is 15 to life. It does go up to 25 to life. So even had he gone to trial and been convicted, there's a possibility.
Well, on these facts, though, it doesn't seem likely he would have ended up after trial with a minimum sentence. Can you and I agree on that?
It's certainly not before this judge.
Okay, because he shot a 26-year-old victim in the neck and torso that caused catastrophic injuries to him, causing his death. So,
yes. I mean, the question is, why is this sentence so out of disproportion and in line with so many other pleas that we see where defendants accept responsibility for a homicide by pleading down to a manslaughter and receive terms that are far shorter than what we see here. And what's remarkable is that this is a 22-year-old without any prior criminal record. So it's both a young man and it's an extraordinary sentence, of course. Thank you.
Thank you so much. And again, thank you to Counsel Namian, I believe, who argued today under the practice order. Thank you both.
Thank you, Your Honor.
Okay, next we have Board of Managers versus 90 William Street. Yes, Mr. Leibowitz?
Leibowitz, but it's Leibowitz, but that's quite all right, Your Honor. I've been called much worse in my time.
Well, thank you and my apologies.
Quite all right, quite all right. Good morning, and may it please the court. I'm here on behalf of all of the defendant appellants today because Mr. Martirosyan, unfortunately, is ill and unable to attend. But for the purposes of this argument, I'd like to break the defendant appellants into 2 groups. The defendant appellants, Stephen Etkin, Rachel Foster, Alan Coetzee, and the Gamcraft Trust, I'd like to, during the course of my argument, identify them as the investor defendants, and the other defendant appellants as the sponsor defendants. And because many of the facts and legal issues are intertwined and overlap as between them, I thought the better way to argue this is, rather than argue each appeal separately, we'd rather, for the sake of clarity and brevity, and I emphasize brevity in that statement, address each of the legal issues with respect to this case, how they affect the group defendant appellants, and to the extent they affect each or any of the individual defendants, point them out as well. So with that said, let me begin by saying, as the index number of the case below shows, this action was commenced in 2011 by the plaintiffs by the filing of a summons with notice. However, the actual summons wasn't served until over 2.5 years later, after the plaintiffs received 7 separate extensions from various trial judges because of various applications they made on behalf of the claim that as long as they were negotiating with the defendants, that they felt that service of the summons would be inappropriate and somehow put a damper on those negotiations. With respect to the investor defendants, they weren't added to this case until 2017, some 6 years after the action was commenced. And after a year and a half, or more than a year and a half, after they had been specifically identified in a deposition given by Mr. Louis Greco, who is one of the sponsor defendants.
But counsel, I just
Yes,
failed
sir.
to see the prejudice that arises from that. Can you talk to that? Speak to that, please.
Well, let's talk about the prejudice with respect first to the sponsor defendants. The sponsor defendants were prejudiced by the
Counsel,
fact.
please answer the question asked, okay?
I'm sorry, I thought you asked me about the prejudice. Wasn't that correct, Your Honor?
Correct.
Yes, so I wanted to address the prejudice with respect to, let me start with the investor defendants. The investor defendants were not added to this case until 2017. And by 2017, when they were added, the plaintiff's motion for summary judgment had already been submitted, fully briefed and submitted. So they were unable to participate in a decision which held that there was a breach of contract by the sponsor.
Are you talking about Linda Greco?
No, I'm talking about Etkin, Foster, Kotze, and the trust. They were not in this case until after the summary judgment motion was fully briefed and submitted. So they never had an opportunity to raise any defenses or issues with respect to either the breach of contract, which is really not their issue.
Counselor, summary judgment was not granted as to them.
Well, it's unclear whether it was granted as to them or not, because fraudulent conveyance
Granted as
claims.
to the sponsor defendants. You're talking about the other defendants.
Yes, I'm talking about the investor defendants, Your Honor, because it's the plaintiff's claim that the fraudulent conveyance determination, which was that there were fraudulent conveyances made both constructively as well as intentionally, are bind my clients. And Mr. Kotze is not in any way, shape, or form involved in this case. He was the grantor of the Gamecraft Trust. The only evidence in this case against him is that he was a grantor. The case against him should have been dismissed because the Judge Crane, who I know and I like, found that there was some ability, or let me find the exact language if you'll give me just a moment. She found that, let me just find it, give me one moment if you will. It may be inferred that Kotze received indirect transfers from the sponsor, but there's no evidence at all to support that finding because Kotze was only the grantor of the trust. The beneficiary of that trust was his wife and his 3 children, and the trustee of that trust was Louis Greco. So Kotze, based on the evidence in the record, had no involvement at all except that he was a grantor. And I think that the judge,
right?
His wife was a business partner of Greco. Nonetheless,
that's not a distant relationship, is it?
It's not, Judge, but nonetheless, there's no evidence to support that any of the money released by the sponsor to any of the investor entities found its way to Mr. Kotze, certainly not directly. And there's no evidence to suggest that it was found to get to him indirectly. If you look at the allegations, the only allegation is that he was a grantor. And as the court knows, if you're not a beneficiary of a trust and you're not a trustee, a grantor has no right to the trust principal or interest. In fact, the trustee has an obligation as a fiduciary to protect the beneficiaries, not the grantor. So I think that the judge simply misunderstood the legal technicalities of how a trust works. But since we're talking about the fraudulent conveyance issue, if the court will allow me, I will. Oh, let me just go back. And I'm sorry, Judge Moulton, I want to get back to your question about how it affects the sponsor defendants, that 2.5 year delay. First of all, the plaintiffs continually stated to the court that they were involved in negotiations, which was true. However, they also said that if the summons was served, they would somehow terminate the negotiations. But plaintiffs have subsequently argued that the defendants always knew about that summons and that they continued to negotiate anyway. So if that is true, why didn't they serve the summons in the first instance and then enter some kind of a tolling agreement with the sponsored defendants to say, look, we had to serve you. We have an order that says we have to serve you. And in fact, we are going to serve you, but you don't have to file an appearance and you don't have to file a demand for a complaint. Let's continue to negotiate. I've done that dozens of times.
What's that got to do with it?
Well, 2.5 years, I don't want to sound trite, but a 2.5-year delay nonetheless is, justice delayed is justice denied. And I know that sounds like a trite statement.
Also, the court below said that the extensions that were the subject of a motion back in 2014, that the court in 2015 denied the motion, and that constituted law of the case. So might I suggest you move on to other points?
Very well, Your Honor. That's what I wanted to do. I want to discuss the fraudulent conveyance claims, which I think are the heart of this matter with respect to the defendants. First, I've already discussed why Mr. Cosi should be dismissed as a defendant in this case, because even though the court may think that it may be inferred that he received indirect transfers, there's certainly no evidence of that. The same is true with respect to Rachel Foster. While Foster entities or entities in which Foster may have had an interest received distributions, Foster did not directly receive any distributions, okay? Furthermore, in the cause of action for fraudulent conveyance, the claim seeks remedies against the 90 William Street companies as well as the sponsored defendants. None of the investor defendants is named in that cause of action. Therefore, it should not apply to them. But let me get to the more substantive issue, and that is that the claims for constructive trust must fail as a matter of law because the plaintiff failed to allege a confidential or fiduciary relationship, as is the law in this department based on the Sutton Apartments and Bradhurst case. So in her opinion, Judge Crane recognized that rule, but she said it made no sense. But the fact that she thought it made no sense didn't give her the right to not follow the rule in this department as it is the current case law. And the case law is that in order to allege a constructive trust or constructive trust for, a fraudulent conveyance, fraudulent conveyance, pardon me, that is not intentional. You must allege a confidential or fiduciary relationship.
Quiet. Somebody got a dog in the background?
Somebody's mic is on.
My wife wishes we had a dog, but we don't.
The Court of Appeals, going back to the Court of Appeals, in the ABN AMRO Bank case, they didn't require that relationship.
But I'm glad you asked that, Judge, but they have never, ever, in the 7 years since this court set the rule in Sutton, and previously in the Levin case, which predated Sutton by 2 years, the Court of Appeals has never reversed or said that the rule imposed by this department is wrong. Furthermore, the legislature has never taken action with respect to that rule. And in fact, the legislature most recently amended the debtor creditor law in 2020 or 2019. It became effective as of 2020, where they adopted certain sections of the Uniform Voidable Transactions Act, but they didn't make any reference whatsoever in any way, shape, or form to the condition precedent that this court found to be necessary in the Sutton case. And
Counsel, what about Justice Moulton? I'm sorry for the feedback.
No, I'm sorry, Judge.
This court in Board of Managers of Lower Condominium versus Gateway followed ABN AMRO, and that's a 2019 case, post Sutton, in other words. And in that case, the facts are very similar to the facts of this case. Would you speak to the import of Board of Managers of Law?
Well, with all due respect, I think the answer is I haven't heard this court or seen an opinion of this court, nor the Court of Appeals, nor an action by the legislature which has changed the rule that this court, a panel of this court imposed in Sutton. And our position is that that's simply still the law in this department. And there's no reason, and I don't think that the plaintiff has given any reason.
Counsel, but you're not dealing with the issues that were raised in Board of Law, and my colleague is absolutely correct that the facts are quite similar to those in this case. So you can cite Sutton, but seeing as Board of Managers of Law came after, you have to deal with that precedent.
Well, all I can say, Judge, is that you have two different panels, I guess, in this department, which have raised two different rules, or one decided not to follow the rule that Sutton had imposed. And so I leave it to this court to decide what the rule is to follow within this department. I don't want to be cute, but I think that's the way the question has to be answered. But I think there are other issues with the court's consent that one other issue I'd like to address with the time I have remaining on my argument. And then
are you going to, counsel, you're out of your 12 minutes, so would you like to eat into your rebuttal time?
Yes, I would, Judge. I'd like to just, whatever time I have at the back end, I'd like to say for rebuttal. But the one other point I want to point out.
Stop. If you want rebuttal, then you have to stop now, and I'll give you a chance on rebuttal. Okay? You're out of time.
Okay.
Mr. Oral, I'll hear from you.
Thank you, Judge.
Please mute your mic, Mr. Leibowitz.
Yes.
Thank you, Justice Manzanet. Let me start right in with the Sutton case. I agree, stare decisis precedent on which counsel for sponsor in particular waxed eloquent in his brief has merit. But as we pointed out, Judge Crane pointed out, Sutton is an outlier here. There's no other case in this department, or actually any other department, or any other court in this state, other than a couple of trial courts which have followed Sutton, that says you need a confidential or fiduciary relationship to make out a claim for constructive fraudulent conveyance. The one case that this court cited in that case, from the Second Department, contrary to the rhetoric in sponsor's reply brief, did not deal with fraudulent conveyance at all. Although he says, when I was speaking to Mr. Martirosian, I was not here today, but his reply brief said the Second Department interpreted the fraudulent conveyance statute. It did not. When I read his reply brief again, and I said, did I miss that? I went back and looked at the Levin case. No, the word conveyance is not there. It was not a fraudulent conveyance case at all. It was a constructive fraud case in which generally you do need a confidential or fiduciary relationship, as in negligent misrepresentation cases. As the Court of Appeals pointed out in the Otto case, ODDO, it's cited in our papers, generally debtor-creditor relationships are arm's length between strangers. In fact, there was no random, whoever was going to buy units in this condominium, they marketed it to the public. And the rule finds that the holding finds no support in the actual text of the debtor-creditor law. I'm going to go one step further. Mr. Martirosian said in his reply brief, this is for the sponsor, our first judicial department is among the most important commercial tribunals in the country, perhaps the world. Other jurisdictions look to its precedents for guidance in addressing similar legal issues. I concur. Complex and high-stakes commercial ecosystems abhor unpredictability and thrive best where the rules of the road are clear and reliably enforced. And I may date myself here in a minute, but I'm old enough to remember when Judge Crane's father was involved in setting up the commercial division here in this county. And he did it here precisely because he wanted people to bring their high-stakes commercial litigation to the state courts, stop them from shunting them off to private arbitral forums or federal courts or other states. And he did that secure in the knowledge that this court, this august body, would be the final arbiter of the law of commerce in the vast majority of cases. I submit it would ill serve that purpose and the purpose of continuity and certainty in the world of commercial law to have a result in a constructive fraudulent conveyance claim differ completely, whether it's brought here in New York County as opposed to across the river in Brooklyn, or upstate in Albany for no good reason. A case that was clearly an outlier, one of many issues in Sutton. Somehow that happened there. You have that outlier holding, but I respectfully submit, and you know, whether Judge Crane was right to disregard it or simply to express her views, this court clearly has.
Can you turn to whether Mr. Coetzee, as the grantor of the trust, was unfairly roped into this litigation?
I can. He's not merely the grantor of any random trust. Gamcraft Trust was a member of the sponsor from the outset of the condominium development, and he was the grantor. He's also the wife of Rachel Foster, who is the recipient of large sums of money through her exclusive. She's not merely a didn't merely have an interest in an entity that received funds. She was the sole member of Dream SDS, wholly owned by her. This is, I can record cited in 1971. She's the sole member. She signs deeds for them. We have that in the record of 694. And we calculated that Dream SDS received approximately $8.2 million in distributions, direct and indirect, from the sponsor.
And
Mr.
SDS, of which she was the only member, was likewise the only member of 90 William Holding.
I don't know that we have that in the record, and I just need to.
That's where I got it from.
Okay, I don't remember that the 90 William Holding. This is a pleading motion, and I've been involved in a lot of pleading motions over the years, and I've never seen one with so much evidence. Now it's true we have canceled checks. We have bank statements. We have transactions.
Excuse me, but Counselor, I parts of it are a pleading motion, but wasn't there a partial grant of summary judgment as to liability on this claim?
Not on the claim against the investor defendants. The
sponsored defendants.
The sponsored defendants. Yes, we're discussing right now whether it was fair to rope in Mr. Coetzee and his wife, Miss Foster, Gamcraft, and Stephen Etkin, who was their tax lawyer and received and at one point had, I think, a 6% interest in sponsor. There is, I should add, there's one part of counsel's brief. Asked the court to decide a question that obviously was never raised below, nearly whether his clients are bound by the summary judgment ruling. That was never raised. It was never decided. I can tell this court that since the briefing in these appeals concluded in May, we have filed a motion in limine with the trial court. We had a trial date in April, but obviously that got pushed forward. I don't know when it will happen. But we filed the motion in limine seeking to determine that, yes, the defendant should not be allowed to offer evidence under fraudulent conveyance claims. The opposition hasn't been filed yet. I presume because of the pandemic, schedules got shifted. And but eventually I anticipate there will be opposition. That issue, we argue, I'll give you just a précis, that parties or their privies can be bound by that ruling under the law of the case doctrine. And we say that applies to the investor defendants. That issue hasn't been joined yet. They haven't opposed it, but someday they will, and then it will be ripe to come back up to this court. If I can go back to just very briefly on the 306B, there's another entire reason to reject that argument. The motion was untimely. They answered the complaint, the sponsor defendants, back in 2014, made their first motion 8 months later, made their second motion 4 years after that. CPLR 3211E requires such a motion based on untimeliness of service to be made within 60 days of filing an answer. They filed an answer. It's actually in their answer. We have two precedents that we cite. Judge Crane cited one of them, from the second and third departments. So I think to avoid creating another conflict between the departments, this court should follow that precedent. There's one point in Mr. Lebowitz's brief I did want to respond to, because when I look back at my brief, 2 points. Let me, on the due diligence point, and Judge Crane had this all before her. We filed the actual complaint in 2013, served discovery requests in February of 2014. It's at 792 of the record, my notes say. There was a compliance conference, and there was a discovery motion, 2 compliance conferences, 2 discovery motions, all in 2014. And basically what happened here, The defendants ran out the clock. If you're talking about the statute of limitation, that's why they made this motion, because the fraudulent transfers all took place mainly in 2009. SDS, the sponsor, actually was defunct, out of business. They closed their bank account by the late 2010, 2011. So they ran out the clock. We didn't get the discovery. We knew some of the names, but we didn't have enough to file a complaint. We got the details as to when and how much.
Counsel, we haven't discussed at all the sponsor defendant's alleged breach of contract. I don't know if you want to stay on 306B or if you want to talk about that a little bit.
I'm happy to move on to that, Your Honor. Basically, we moved for breach of contract on a very discrete set of issues. We had a big complaint and a RAND report with 100 pages, but we moved on 7 discrete points, and Judge Crane granted summary judgment as to 6. She actually denied summary judgment on 1 point. And on each of those points, we submit there is no actual battle of the experts. They submitted an affidavit from Mr. Procida, claimed to be an expert, but on almost every point, his answer was, we have a TCO. Therefore, There can't possibly be a violation.
Justice Crane found him to be an expert on insulation, and that was it.
That was, well, I don't think she actually found him to be an expert. She said, I'll put off to later whether someone who's interested. This court in the loft space case, which involved, I think, Judge Manzanet, you were on that panel, and some of the same defendants, the Grecos, held that a temporary certificate of occupancy at most is a rebuttable presumption and no more. And we've rebutted that presumption in this case. And by the way, this court affirmed that holding in the West 58th Street Millionaires Row homeless shelter case in August of this year. So the fact that there's a TCO is no defense to, for example, the catwalk. It's an outside surface on top of the building. The only way to get to the cooling tower, there's no guardrail there. They said in the offering plan there would be. The only answer from Mr. Procida is, I think, page 94 in the record. It's in his affidavit, I'm sorry, is that, well, no one should be walking there, but it's the only way to get to the cooling tower if you need to fix it. They have no defense to that. As to the hot and cold water risers, again, he says we have a TCO, it must be right. The fire stopping, his answer was, well, you say in your report that all the penetrations were sealed. He ignored that. In fact, that was just inside the units. The RAND provided, and it's an exhibit to Mr. Marakovich's affidavit, a separate report dealing with fire stopping in other parts of the building. Sound transmission, we have an acoustical expert affidavit at 1636 of the record. At 1643, he tested all the units and found that they all were well below the code, building code. And again, Mr. Procida has no answer other than we had a TCO. And finally, we had some ADA issues with stairs that were too high or missing rails. Those seem pretty clear cut. And there was no significant answer. Mr. Greco, in his affidavit in opposition to summary judgment, said, well, we haven't had any damages because the unit prices have gone up over the years. That's not relevant to a breach of contract, where the question is, did the sponsor undertake to do certain things they did not do or did defectively? And he cited no precedent for that, and that's I submit no value in a breach of contract claim. Your Honors, if you have no further questions, I'm happy to rest.
Thank you so much. Mr. Lebowitz, you may proceed. You have 3 minutes.
Thank you, Your Honor.
3 minutes, no more, okay?
Thank you.
Okay.
So I will be brief. One, let me start with respect to Mr. Coetzee. I didn't hear Mr. Orrell say anything which creates liability for Mr. Coetzee. He said that he was the grantor of the trust. At one time, the trust was a member or an interest member. No, the trust was a member, Judge. Mr. Coetzee was never personally a member. There's no such allegation. The trust was the member, and again, he was the grantor of the trust. So I'll move past that. I hope I've made that clear. I want to address one issue which was not addressed, and that is with respect to the specificity of the claims with respect to the fraudulent conveyance, because there was no specificity with respect to when the debtor allegedly, when the sponsors allegedly became insolvent, and when they knew and what they knew about these claims that the sponsor, that the defendant, the plaintiffs allege were brought. These are all critical elements in an intentional fraudulent conveyance claim, as well as a constructive fraudulent conveyance claim as to when a debtor would be, or a defendant would be rendered insolvent. And I just want to make 2 quick points on that, which is in their brief, Mr. Orr points out that the sponsors distributed over $10 million between 2008 and 2009, which were distributions. But he doesn't say who got legitimate distributions. And for instance, Mr. Etkin, one of the investor defendants here, got $600,000. If the sponsors retained $10 million in their accounts and gave Mr. Etkin $600,000 in checks marked distributions, which is what the record says and what Mr. Greco testified to, when and how did that render the sponsor insolvent? So the fact that they did not plead any specific transactions which rendered them insolvent or which were made with an intent to hinder certainly fails with respect to the intentional fraudulent conveyance claims, and we believe also damns the fraudulent conveyance claims with respect at least to the motion for summary judgment. Their proof is entirely inadequate with respect to the specificity of insolvency, when the sponsors knew, what they knew, and when the transfers rendered them insolvent. So now I want to just finish up, if I may, with respect to the breach of contract. All I want to say is we believe, or it's my opinion, that the judge interposed herself as in the role of the jury by finding that Mr. Procita's testimony was not credible. Credibility is a jury question. And if there's a question of credibility, it's not to be determined on a motion for summary judgment, but rather by a jury at a trial. I thank you, Your Honors, for allowing me the time today.
Thank you so much. You have a good day.
Thank you all.
Thank you. The same to you. Bye-bye.
Bye-bye. All right, Zemsky versus Prokofiev. Ms. Mahoney, I gave it my best shot.
I can't do it either, Your Honor.
Okay, good. Then it makes me feel better. All right, you go ahead.
Thank you.
You have 7 minutes.
Good morning. May it please the court. Plaintiff appellant seeks reversal of the Supreme Court's order granting the defendant's summary judgment. Plaintiff submits that the Supreme Court's order should be overturned because the defendants did not meet their prima facie burden and because there are issues of fact as to both liability and causation. Before his discharge from the Lenox Hill Emergency Department on Saturday, April 11th, 2015, Jason Zemsky exhibited all of the signs and symptoms of testicular torsion, including increasingly severe pain in his testicle, testicular swelling, and an abnormal lie in the testicle. The defendants argued that they met the standard of care by performing a scrotal ultrasound for Mr. Zemsky, and when that was negative, by diagnosing him with epididymitis. However, the defendants and their expert completely ignore what happened after the ultrasound while Mr. Zemsky was still in the emergency department under the defendant's care. The defendant's records and Mr. Zemsky's testimony establish that Mr. Zemsky had a demonstrated increase in his testicular pain after the negative ultrasound, so much so that he had to have 3 different pain medications, including IV morphine, administered to him within the span of less than an hour. And that medication was administered about 2 hours after the ultrasound. Then, about an hour after the medication was administered, Mr. Zemsky was discharged, and at the time of discharge, he testified that he was in excruciating pain. And he looked to the PA who was discharging him and said, "Are you sure I should be discharged? I'm really in a lot of pain here." After discharge, Mr. Zemsky's condition remained the same. For the next day.
Does the record reflect if he was discharged with any painkillers?
Yes, Your Honor. He was discharged with Percocet, which he continued to take over the next day and a half or 2 days, but he testified that his pain level remained the same, even though he was taking that Percocet. His pain level remained at about 8 or 9 out of 10. Additionally, through that weekend, he still had the swelling in his testicle and the elevation in his testicle. So whatever he was suffering from over the weekend, he was suffering from before his discharge from the emergency department on April 11th, because his condition remained the same. By the time that he got to a urologist on Monday morning, the urologist said, "You really need to go for another ultrasound, and it was determined later that day via surgery that his testicle was necrotic. And so plaintiff submits that all of these facts, when viewed in a light most favorable to the plaintiff, at least raise questions of fact as to whether the hospital should not have discharged Mr. Zemsky in excruciating pain, whether they should have done more to investigate the cause of his pain, whether they should have kept him for continued monitoring in light of this increasing pain, and whether they should have done an additional ultrasound. As we argue in the brief, the defendants did not meet their prima facie burden on summary judgment.
Counsel, you don't think that Dr. Nelson's affidavit was sufficient to meet that prima facie burden?
Well, Your Honor, there are a few deficiencies in his affidavit which the respondents didn't really address in their brief. Number one, and probably most critically, he ignores again what happened after the ultrasound. What we have in this case is it's undisputed. We have a condition where the condition can appear, go away on its own, and then reappear. And so that means
that's what your expert stated, and thereby you say rebutted Dr. Nelson's statement.
Yes, Your Honor. Yes. So the problem with Dr. Nelson's affidavit is that, again, he ignores what happened after the negative ultrasound. He relies solely on the negative ultrasound. But Mr. Zemsky had a change in his condition after the ultrasound, which indicated further care, which the defendants didn't provide. Dr. Nelson's affidavit is also conclusory as to causation because all he says is, again, they performed the ultrasound, and so nothing they did or didn't do contributed to his injuries. But Dr. Nelson doesn't tie that into any record evidence. He doesn't say anything about what happened after the ultrasound, either in the hours after the ultrasound or the days. He doesn't talk about how or when Mr. Zemsky's testicle became necrotic, as we know it did on the following Monday. He doesn't talk about the surgery results. So in that regard, his affidavit is conclusory on causation.
Was there any attempt by the doctor in the affidavit to address the discrepancy between the nurse's note that he reported 3 out of 10 in pain and his testimony that he was in excruciating pain and questioned the timing of his discharge? Does the affidavit at all address that discrepancy?
The affidavit of our expert, Your Honor?
No, of the other side.
Okay. No, I don't believe so. I don't believe the defense expert talks about really anything that happens after the negative ultrasound. I think the defendants generally rely on that nursing note, which, as we say in our brief, raises a question of fact. There is a nursing note about 15-20 minutes before Mr. Zemsky is discharged, saying that he has a 3 out of 10, but Mr. Zemsky said by the time of discharge, he was pale, white as a ghost, sweating, and in excruciating pain. So, that's a classic question of fact. I'd also like to talk just briefly about causation, because I know that's part of what the Supreme Court granted summary judgment on below, because the court did find that we created issues of fact as to liability. So with regard to causation, I just want to say that I believe that there are at least 5 pieces of evidence here that raise a question of fact as to causation and preclude summary judgment. Number one, again, the nature of the condition that we have at issue here. This is a condition that can appear, go away on its own, and reappear. So again, just because you have a negative ultrasound at one point in time doesn't mean that the testicle cannot retorse, which is obviously what happened here. Number two, Mr. Zemsky's increased pain and the fact that that increased pain continued throughout the entire weekend until he was finally diagnosed on Monday. Number three, the fact that when he went to a urologist on Monday, that urologist said, you should go get a repeat ultrasound, even though the urologist knew he had had a negative ultrasound 48 hours before, meaning the urologist knew that there was some change in his condition, and that change had occurred again in the emergency department before he left Lenox Hill on Saturday. Number four, just the condition of his testicle by the time that the surgery was performed on Monday, which the defendants and their expert ignore. Again, during the surgery, it shows that the right testes and the epididymis were black in appearance. There was significant thrombosis found, and the testicle could not be saved. So clearly, something was happening with him before his discharge and over the weekend that led to the testicle to become necrotic. And then number 5 is our expert opinion, which is from a board-certified urologist with decades of experience who looked at all this and said, based on this man's clinical presentation, he should not have been discharged in excruciating pain, and there should have been a follow-up as to what was causing that pain and a further ultrasound.
Thank
so
you
for all
so
those
much.
all those reasons, thank you so much.
Okay. Mr. Rodriguez, you have 7 minutes. You're on mute.
Sorry.
Okay.
Good morning, Your Honors. Leilani Rodriguez for the defendant respondents. I'd like to start by just pointing out that the only remaining defendants in this case are the ER practitioners, the physician's assistant and the attending physician, Dr. Menino, not the urologists and not the radiologists. And these practitioners are permitted under there's well-settled case law to rely on these specialists. They're permitted to rely on things of radiologists, and in this case, radiologists' findings from the ultrasound ruled out torsion and suggested
yes, counsel, but the nature of this medical situation is such that it can rapidly and suddenly change. That I saw nothing in the record or the affidavit that contested that. Am I wrong?
You're correct, Your Honor, but I would argue that plaintiff presented to the hospital with complaints of 10 out of 10 pain. Thereafter, the ultrasound was performed and it ruled out torsion. And according to the medical records, his pain went down, and 20 minutes before he was released, he was a 3 out of 10.
Well, that's what the notes say, but his statements contradict that. How is that not an issue of fact?
Okay, so it could be an issue of fact. I would point out that this is not a lay witness, that he is an attorney, that I'm not saying...
That doesn't matter. So now attorneys can't get sick? I mean...
No, they can, but I'm just saying he has a better understanding of what's necessary in this case.
Counsel,
but I would...
What you are suggesting goes to credibility. And you and I both know that a judge on a summary judgment motion cannot hinge their decision one way or the other on something that requires assessing credibility. So again, how is the difference between this note, which of course the plaintiff had no way of knowing what the nurse wrote, when she wrote it, didn't sign off on it. So how is that not a question of fact that requires a trial?
Well, there was also another note by P.A. Demarest that said his pain was controlled with the morphine. But even if there is a question of fact with regard to his pain, there's also the issue of causation, which is what the court below hinged its decision on, finding that it was speculative for a plaintiff's expert to say that this plaintiff should have remained in the hospital until sometime in the future that's unknown when his test will be forced. Speculation. Also
you are breaking up.
I can't
We're
hear
having
you.
trouble understanding you. Your reception is breaking up.
Oh, I apologize.
It's very muffled. I'm so sorry.
I'm sorry. I don't know how to fix it. Can you hear me now?
Yeah, you just came back in.
May I just go back a little bit to the beginning of your argument? Was my belief that Lenox Hill was still a defendant in this case?
Correct, Your Honor. They're vicarious in this case.
Because you said it was just, before you said it was just Menino and Demarest, but the hospital is still there.
I meant the practitioners, but the hospital is there for vicarious liability.
Yeah. I don't understand why you say it's speculative, what the plaintiff's expert said, because if you have someone that is in such extreme pain that they're white, shaking, and all of the other indications of a problem that the plaintiff says he had, that for the plaintiff's expert to say that he should have been retained in the emergency room a little bit longer till that was resolved, to me doesn't sound speculative at all.
Well, he was diagnosed with another condition that was also considered a very painful condition. And that condition he was being treated for with antibiotics.
Except that the affidavit of plaintiff's expert explained that people who suffer with that other condition, which I can't pronounce, are typically people with a certain lifestyle that this plaintiff's did not fit.
To that point, I would say that the plaintiff's expert affirmation said most likely, and that I believe it was Dr. Menino who testified that it's not necessarily a sexually transmitted disease, that it could have other causes other than sexually transmitted diseases. And it was the urologist who diagnosed epididymitis. It wasn't the ER physicians. And the urologists were not sued in this case. And they had extensive conversations with plaintiff about his sexual history. I just want to go back to causation because I think that's really the key to this case. The issue really is whether Dr. Menino and PA Demarest were acting reasonably when they relied on the urologist's diagnosis of epididymitis and they released him. Whether or not there's an issue of his pain level, their instructions when he left was that if his pain continued or got worse, he was to return. And he didn't do that for 2 days. Instead, he went to his doctor. There's no way for
he was advised that he was going to continue to have pain until the antibiotics kicked in. Isn't that what the doctor advised him? So based on that information, it doesn't seem so unusual that he would then wait and bear it, accepting the doctor's advice.
Well, the truth is there's no evidence here when his testicle retorsed. We don't know if it happened when he was in the emergency room. We don't know if it happened Sunday night. That's why the court below said it was speculation for plaintiff to say it could have been prevented had he stayed a few more hours, had he stayed one more day. There's no evidence of when it happened. So that's why it's speculation and there's no causation.
Okay, thank you so much.
Thank you, Your Honor.
All right. And Lewis versus Nitra, Ms. Whiting, you have 5 minutes.
Good morning, Your Honors. The primary issue before this court is whether Mr. Lewis should be dispossessed of his over 50-year housing authority tenancy based on a decision rendered after a hearing held on his default in appearance, a default forced by NYCHA, who made no effort to have him produced or appear by video conference.
Counsel, him and his family lied repeatedly about where he was, kept saying he was sick when he was in prison.
He did not lie, Your Honor, and there's no indication on the record he had anything to do with that. No one contends that he did. That was his sister. When it became clear that in fact he wasn't.
Did he notify anyone to tell them he was in prison?
No, Your Honor.
Well, he was the one who made the petition to stay, no?
He made the petition to...
and he knew that they were going to be scheduling hearings. Isn't that right?
That's right, Your Honor.
Well, they can't schedule a hearing if they don't know where you are.
Your Honor...
Why should he not be held responsible for not informing the agency that he was requesting a hearing from?
Your Honor, he did not notify the agency, but we contend that when they determined that he was incarcerated, they did nothing to have him produced or appear by video conference, which they needed to do because this was a dispositive hearing at which he was going to lose his home. And
Counsel, if I may, I would like to go back because you're saying that this was a default, but how was it a default when there was a guardian ad litem that appeared on his behalf?
The guardian ad litem was not appointed with his consent, and even had she been appointed with his consent, she did absolutely nothing. She effectively stated her name for the record, and that's the entire amount of her representation. It's not contested that she did not even attempt to reach him in prison. She said nothing on his behalf. She did not confront witnesses. She presented no testimony or evidence. She did not represent him. She was physically there, but she did nothing more than that, Your Honor.
I just want to go back to this default, because you're saying it's a default, but you didn't move to vacate a default. What you did was, I want to finish, what you did was you requested a new hearing based upon the alleged violation of the due process rights. This was never raised below.
Your Honor, it was raised in the request to vacate the default, the request that we made to the Housing Authority in July of 2018. It was effectively a request to vacate a default. It's not a request for reconsideration, because it's not a request to re-argue things that had been argued before. It's a request to be able to be present and to present your testimony and your evidence and confront witnesses. So that was a request to vacate, and when that was denied, we timely filed the Article 78, which was denied below.
Can we address the substance of the denial, which was that he was ineligible because of his criminal background checks, having failed criminal background checks. And thereafter, as we know, as we've been discussing, he gets convicted on a robbery in the second degree and sent to prison for 7 years. How on the substance is there any issue here based on his convictions? There's no way he is going to be approved for housing in a NYCHA housing.
Your Honor, that would have been a matter for the hearing officer to decide. He would have been able, had he been present, the guidelines that the Housing Authority sets forth for criminal record denial are guidelines. They are not hard and fast rules, and an individual is...
So you know as well as I do that we have grandmothers thrown out of housing because they let their grandsons who are convicted of selling drugs on the property, they get kicked out. So clearly someone who has a robbery conviction, a violent one at that, under what universe would that be someone that NYCHA would approve to live in New York City housing?
He would have been able to explain, Your Honor, that what actually went down at that conviction, which was that the severity of it is much less, the facts of it are much less serious than what the title of the conviction would indicate. He was convicted of effectively attempting to steal $330 worth of cologne from an upstate Macy's, and when apprehended, saying to the security officers, "Don't harm me, I have a gun." He did not have a gun. That was it. That was, on that basis, he was convicted of robbery in the second degree and incarcerated for 7 years. He would have been able at the hearing, and this is one of the things that the Housing Authority's manual allows, he would have been able to explain what happened and the severity of it and why it's not as bad as it looks. He also would have been able to present letters from neighbors. He would have been able to present testimony of people who have known him for the time he's been in the Housing Authority and would be able to say good things about him. He'd be able to talk about his plans for reentry and what he intended to do upon release. He would have been able to present as much mitigating evidence as he had, but the fact is he was not able to do that. And it's not a hard and fast conclusion that he would have been denied housing. It isn't, and he should have been able to present his case. So he wasn't, and what happened is that the hearing was dispositive of his tenancy rights, and we moved timely to have our Article 78 petition was timely filed because it was filed within 4 months of the denial of the request to vacate.
No, I'm sorry. The case law does not support you, counsel. The time does not begin to run from a denial of a request to vacate, the time begins to run at the issuance of the decision at issue.
But Your Honor.
So you are way out of time with respect to that decision, which I believe was decided in December of 2014.
Your Honor, there is no proof that my client received a copy of that decision at any point up until end of April 2018.
And yet, even if that were true and there were any case law that says the time begins to run from the time that you learn, if he learned in April, this petition wasn't filed till November. So you are still out of time.
The case law, as I understand it, Your Honor, Yarborough, says that a request to vacate, that the statute of limitations runs from the request to vacate. There's no rule in the Housing Authority Manual or otherwise that says during what time you have to make the request to vacate. If you looked at CPLR 5015 as guidance, perhaps, you'd have a year to be requesting to vacate. We did it much quicker than that.
Counsel, did you raise that issue below? Is that issue preserved for appeal?
It's substantially preserved, Your Honor.
What does that mean, substantially preserved?
It's preserved. It should be preserved, Your Honor. The words used are not talismanic, and all claims were fairly presented below.
Thank you.
You're welcome.
Mr. Kramer.
Okay.
Good morning, Your Honor. Seth Kramer. Seth Kramer for respondent. I'll first address the issue of default in Yarborough. The claim was waived both in the letter in 2018 submitted to the hearing officer and in the lower court papers. It's never suggested that the determination was made on default. As Justice Kennedy pointed out, there was a GAL present at the hearing. A GAL is appointed to appear in the stead of the participant. But also, I think it's important to note the history of what happened between 2010 and 2011. So during this time, petitioner was in prison, and this was the initial hearing that took place. And the issue in that hearing was whether a 2009 conviction for petty larceny precluded him from succeeding to the tenancy, that 2009 conviction. And there was participation at that hearing. The petitioner's sister appeared, presented documents, presented letters. The GAL presented reference letters. And based on that, the hearing officer actually went ahead and sustained the grievance, found he had been rehabilitated. Now, it turns out that those documents were fraudulent, but the point is that there was participation at that hearing. Then upon learning later on that those documents were fraudulent, that he was actually in prison the entire time, the hearing officer reopened the hearing to receive the evidence pertaining to the new conviction. And in the hearing officer's decision, they find that the 2009 conviction, what was the initial issue in the administrative hearing, that he could not show rehabilitation from a 2009 conviction because he had been resentenced, new conviction, and was in prison still at the time in 2014. While maybe in 2018, there may be evidence that they'd be able to submit, or today, evidence that could be submitted to show that he's rehabilitated, the applicable period of time isn't now, is at the time of the hearing officer decision. And in 2010, and even in 2014, he was in prison for petty larceny, for felony robbery, and was still in prison for another 3 years after that. And I don't believe someone can show rehabilitation from a crime while they're still in prison and not, and in that confined system where they're not even permitted to do anything improper or anything wrong. In terms of the statute of limitations, the prison confirmed that they received the determination, the mail with the determination 2014. If this was a close call on statute of limitations, because the prison said that we're going to hold it for him. So maybe if he commenced the proceeding 5 or 6 months after that receiving that determination 2014, this would be a close call. But they said he didn't commence this until 4 years later. Even if he didn't receive a determination, Justice Mansonet, as you pointed out, he clearly knew about the determination upon being released from prison in December 2017 when he appeared in the holdover proceeding, and then when he received the summary judgment motion that discussed the determination. As we say in our papers, petitioner's claim is really a due process claim, and a due process claim, as appellate authority establishes, must be timely raised. And for that reason, we believe the lower court properly dismissed the petition.
Thank you.
Thank you.
Ms. Whiting, you have 2 minutes.
Thank you, Your Honor. The hearing that Mr. Kramer discussed, where my client's sister misrepresented facts, that hearing was vacated, and the decision was vacated based on New York City Housing Authority's motion. And so what we had was a new hearing with a guardian who'd been appointed under false pretenses, and this was an opportunity for new evidence to be presented, an ab initio. It was not simply building on evidence presented below. The evidence presented below was turned out to be false and had nothing to do with my client. He had nothing to do with presenting the falsehoods. This was his opportunity to be able to show that he was in fact somebody who should be granted, continued tenancy rights in a place that he lived for 50 years. Also, it bears noting that the petition in this case, which was not served on Mr. Lewis, does not even include a copy of the hearing decision, nor was the document that was sent to the prison the hearing decision. It was a one-line letter saying the grievance is not sustained, saying nothing about what that meant or what a person was supposed to do as a result of a grievance not being sustained. But in any event,
Counselor, if I may,
yes,
let's assume that he did not receive the letter in 2014. He was released from prison December 2017 and appeared in the holdover January 2018. So can't we make the argument that certainly January 2018, he was aware of the adverse decision, but yet failed to timely commence an Article 78. Can you address that?
Yes. It is true that he appeared in court. Certainly, I'm not contesting that. But two things. One, he did not have counsel. But two, the petition in this case simply says, your mother died, you have no tenancy rights, end of story. It does not append a copy of the hearing decision, and it doesn't give the actual facts, other than the fact of the mother's death, upon which the petition was. Okay. So imputing knowledge of the actual facts of the grievance doesn't work here until the end of April 2018, at which point he and his counsel, we were retained.
But why? I mean, I'm not hearing what he did between that appearance and April.
He appeared in court a few times. He attempted to find counsel, and he did find us, and we were retained in May. And so in May, when we took a look at the materials and looked at the grievance and looked at the file, which took a while to get, we were able to determine that the decision had been rendered effectively on default. We asked to vacate that default. When that request was denied, we timely filed the Article 78.
Thank you so much.
Thank you.
Thank you. Okay, Ms. Rojas, are the attorneys on Capstone available? Counsel on Capstone Business, are you present?
Stacy, did they register?
They never responded to the second set of invitations.
Thank you so much. The appellate division now stands adjourned.